everyone, my name is Amy Bailey and I am an attorney here at Sivia Law, and I wanted to give you today just a brief introduction to the different types of intellectual property that are out there. A lot of people don't understand what intellectual property means, and it can cause a lot of confusion down the line. So typically, intellectual property is considered to be just the protection and ownership of ideas or the expression of those ideas. So there are four big categories: copyrights, patents, trademarks, and trade secrets. And trade secrets is the easiest of them to understand. It's, for example, the Coca-Cola recipe. It is a recipe that could otherwise be patented, but rather than be subject to the limitations of a patent, it's been kept as a trade secret. And by keeping it as a trade secret, it's just a secret that you keep for an indefinite period of time, and you have exclusive use of whatever your trade secret is for the duration that it's kept a secret. A patent, on the other hand, is sort of the exact opposite of a trade secret. A patent is a limited duration property right relating to an invention that is granted by the United States Patent and Trademark Office. When you go about obtaining a patent, you are detailing every single piece of your invention, and that information goes into the public domain. And for a period of 20 years from the date you file your invention application, you are granted exclusive rights associated with that patent. But at the end of that 20-year period, everyone is capable of going out there and making your invention and using it in a competitive market against you. A copyright is harder to define because it is so many things. It could be a literary work, it could be a musical work, a dramatic work, a sculpture or architecture, it could be some sort of other pictorial or graphic work, it can be a motion picture or other audiovisual work, or a sound recording. And it's important to note, though, that copyrights only protect that particular expression or idea, whatever it is. Copyrights do not protect the thing itself. So you can't write a book detailing a method of operations and then claim that method of operation is your own. You are only claiming that particular written text detailing the method of operation. So where the method of operation is potentially patentable, your written explanation of that method of operation is copyrightable. So what is a trademark? A trademark is a word or other designation that identifies the source of goods or services in the marketplace. A trademark can be a whole host of things. It can be a word, it can be a name, a symbol, device, or some combination thereof. There's a wide variety of trademarks that are trademarkable out there that you see every single day without a doubt. There are different types of trademarks. There's a whole process involved with getting a trademark and maintaining your trademark, and we will detail trademarks more exclusively in following videos. So what is a trademark? A trademark is a word or other designation that identifies and distinguishes the source of particular goods or services in the commercial marketplace. The trademark can last for an indefinite period of time as long as you adequately register and maintain filings as required by the USPTO or your state registration office. If you have just a common law trademark, then it can last indefinitely too, but there are other limitations involved with common law trademarks, and we will detail all of the differences between common law and state and federal registrations of trademarks in future videos.